Chapter 24. Criteria of Domicil, double residence. SS 421. Difficult to determine the domicile of a person who resides in different places. It is sometimes very difficult to locate the domicile of a person who has domestic establishments in different places, or who resides in different places at different seasons of the year. We have seen that among the Roman jurists there was a difference of opinion concerning the case of one who appeared to be equally established in several places, some holding that he had several domiciles, while Labeo held that he had none, and Celsus that the location of his domicile depended upon his choice and intention. The remarkable case of two contemporary residences put by Lord Alvanley at the conclusion of his judgment in Somerville v. Somerville has already been referred to and discussed. In the same case he lays it down that a merchant whose business lies in the metropolis shall be considered as having his domicile there, and not at his country residence, while a nobleman or gentleman having a mansion house, his residence in the country, and resorting to the metropolis for any particular purpose, or for the general purpose of residing in the metropolis, shall be considered domiciled in the country. But this distinction, which was doubtless founded upon the usual habits and customs of persons belonging to the two classes mentioned, is far from being applicable to all cases. And, indeed, no definite rule upon the subject has been or perhaps can be laid down. SS 422. National Domicile. Where the question is one of national domicile, no doubt the principle that the former place of abode must be completely abandoned as a place of abode before a new domicile can be acquired should be applied with great strictness. And hence, where a person has domestic establishments in several countries, he must be presumed to retain his former domicile as long as he retains a domestic establishment in the country where such domicile was. This, however, probably would not exclude the possibility of change in case an establishment is kept up in such country merely for his accommodation upon occasional visits. But upon this point there was, as we have already seen, considerable diversity of opinion among the law lords who took part in the decision of Maxwell v. McClure, Lord Wensleydale, expressing himself as unable to conceive a case in which a change of domicile could occur so long as a residence was retained at the place of former domicile. SS 423. Municipal domicile. The greatest difficulty in ascertaining which of two contemporaneous residences shall be considered the domicile arises in cases of municipal domicile. The presumption of continuance of an ascertained or admitted domicile, of course, applies in cases of this class, although not with the same force or to the same extent as in cases of national or even quasi-national domicile. And therefore, while the burden of showing a change of municipal domicile rests upon him who alleges it, it is discharged by showing slighter facts then, and without the necessity of proving abandonment to the same extent as in the cases of national domicile. Thus a person, under some circumstances, may change his domicile from one municipal district to another, although he has not abandoned the former as a place of abode, but still retains a household establishment there, and resorts thither to spend a large portion of this time. But what circumstances shall control, or what shall be the extent of the abandonment, if at all, of the one place or establishment in the other, it is impossible to state in advance. Each case must be determined by its own circumstances, and that place must be adjudged to be the domicile which bears, most of all, the characteristics of home. SS 424. May a person having two residences select his place of domicile? Into the determination of the question, the choice and selection of the person often enter largely, but such choice and selection must usually be evidenced by acts, and will not be permitted to control a preponderance of evidence in favor of another place. It is sometimes said that in cases of doubt the person may select either place as bis domicile, but this is true only in a qualified sense, and, moreover, it is applicable only to cases of doubt, strictly speaking. Said Shaw, C. J. in Lyman v. Fisk, it is often a question of great difficulty, depending upon minute and complicated circumstances, leaving the question in so much doubt that a slight circumstance may turn the balance. In such a case the mere declaration of the party, made in good faith, of his election to make the one place rather than the other his home, would be sufficient to turn the scale. But it is a question of fact for the jury, to be determined from all the circumstances of the case. So it was left in the case of Makepeace v. Lee, cited by the Chief Justice in Pick. 378. The election of a man to pay taxes in one town rather than another may be a good motive, and a justifiable reason for changing his habitancy, and if such election is followed up by corresponding acts, by which he ceases to be an inhabitant of the one, and becomes an inhabitant of the other, his object may be legally accomplished. But such an election to be taxed in one town rather than another is only one circumstance bearing upon the question of actual habitancy, and to be taken in connection with the other circumstances, to determine the principal fact. But the court are of opinion that the effect of the instruction of the court on the trial of this cause was to withdraw all the evidence from the consideration of the jury, except the election of the plaintiff to be taxed in Boston. That this direction was not correct, and that the question whether the plaintiff was an inhabitant of Waltham should have been left to the jury, upon all the facts and circumstances of the case. SS 425. Domicil of a person whose dwelling house is on the dividing line of two districts. Another aspect of double residence presents some difficulty, and has been treated very differently by different jurists, namely, when the dwelling house of a person is upon the dividing line of two districts. According to the French authorities, the principal entrance determines the domicile, little importance being attached to the question in which district the greater part of the house is found. The Massachusetts cases, based upon the English cases of settlement and court leet, hold the person to be domiciled in that district in which he mainly and substantially performs the acts and offices which characterize his home, such as eating, sleeping, sitting, and receiving visitors, but, above all, where he habitually sleeps, if that can be ascertained. A similar view has been taken in Maine. The Supreme Court of Pennsylvania, in a recent case, adopted a rule apparently different from either of the foregoing, namely, that the domicile is in such a case to be determined by the acts, declarations, and intentions of the person, showing in which district he elects to fix and maintain his residence.